Justice Kehinde Ogundare of the Federal High Court sitting in Ikoyi, Lagos on Thursday, May 2nd, 2024, adjourned the further hearing in the trial of Pascal Okechukwu, aka Cubana Chief, till June 5th, 2024. Okechukwu was arraigned on Wednesday, April 17th, 2024 by the EFCC on a 3-count charge bordering on abuse of the Naira. The two of the counts read that Okechukwu Pascal abused the Naira on 2 separate events. At the resumed sitting of the court on Thursday, Okechukwu, through his lawyer Chika Osulu Ujuku, told the court about a plan by his client to enter a plea bargain with the EFCC. Ujuku also sought to withdraw his earlier preliminary objection filed on April 24, 2024, challenging the jurisdiction of the court to entertain the charge. The prosecution counsel did not oppose the withdrawal of the application. And now to discuss this further, we're joined by a legal practitioner, Elvis Asia, and he joins us live via video chat. Elvis, a very good morning to you. Let's get started very quickly. How does the decision of Cubana's lawyer to settle out of court with EFCC reflect on its, approach to combating Naira abuse?
Well, I mean, it's a strategy that is open to the defendant in the criminal proceedings. The relevant provisions of the EFCC Act, which the lawyer referred to, clearly gives the EFCC the powers to compound an offense. Compounding meaning that the EFCC can have an arrangement with the defendant, have a settlement arrangement with the defendant to pay some money or fine or whatever, in exchange for the withdrawal of the action. So it's something that is open, that's open to the defendant to do. And of course, don't also forget that there are also issues as to whether or not the EFCC actually has the legal competence to prosecute this kind of charge. And so, both parties can decide to meet midway. And again, the whole idea of trying to discourage the abuse of Naira, which has become an epidemic in our society, it's, to some extent been achieved, whether or not there's a settlement. At least now people are aware that, it is criminal to abuse the Naira the way and manner we have been doing over the years. And I also hope that part of the settlement should be that Mr. Pascal should use his social media presence, to educate members of the public on the issue. So it's a smart move. There's a legal precedent for it. The only challenge I have is whether or not that section 14, section 2 of the EFCC Act can actually be used to compound this offense. Because the abuse charge is not an offense under the EFCC Act, it's an offense under the CBN Act. And by virtue of that section 14, it is actually the EFCC has the power to compound offenses under the EFCC Act. That's a technicality which I believe that can be settled out during the course of this out-of-court settlement.
Let's look at the out-of-court settlement between Cubana Chief Priest and the EFCC. What are the implications of these in enforcing the Central Bank Act and similar regulations?
Well, I mean, like I mentioned earlier, it's a legal strategy that is open to the defendant, and it's something that the EFCC has the powers to do. Yes, I would have hoped that we would continue to be very strict on this in order to ensure that we nip this at the ball, because there are so many issues that can arise from the abuse of land. It can be an instrument for money laundering, because imagine if criminals have access to huge cash, for example, and then they go to a party straight, it masks the origin of that fund. The money cannot become legitimate. The man can go to the bank and deposit it and say, oh, I had a party, and then I was paid money. So it's a very serious offense. And then you look at the impact on our society, what it's doing to young people, the craze for money. And so, it's something I would have expected that, we should continue to be strict, but we should do it legally. We should do it within the confines of the law. Have the appropriate authority should be the ones to prosecute, because there's, like I said, the issue that's hanging on EFCC as well, that it really has the powers to do so, because the CBN Act is not one of the things that I think the EFCC is empowered to enforce. And so you are right that we should continue to insist on strictness, and I think that was what made the judge in the Bobrisky's case to be very strict by imposing both a fine and imprisonment, instead of an option of fine. So that this can serve as a deterrent to other member society. But again, some of the goals of discouraging people have been achieved. Like I said earlier, people are now aware that this is a crime, and I hope that part of the settlement in this particular case will be for the Cubana Chief Priest to use the social media presence to orchestrate a fight against Naira abuse.
Elvis,
I hope that.
You just mentioned the Bobrisky case, and so before I would let you, I don't want us to skip away from that, because that was very important, which takes me to my next question about how the judiciary's response, if you compare it to recent cases, and case in point, Bobrisky's 6-month imprisonment. What does this, when you look at their comparison, he has, Bobrisky, she has 6 months imprisonment, and then there's the Chief Priest Cubana and his alleged abuse and how this has been now going out of court. What does this reveal about the sentencing disparity in similar offenses?
Yeah, I mean, it's really, yes, members of the public may suspect it and begin to think perhaps it's because one party has more influence on the judiciary. That may not necessarily be the case, because in sentencing, the judges have no discretion. For example, the punishment for abuse of the Naira, it's a fine of not less than 50,000 or a term of imprisonment of 6 months, or both. So a judge can decide to give an option of fine. A judge can decide to give imprisonment, like it was done in Bobrisky's case, or award both a fine and imprisonment. So legally speaking, the judiciary will be within its legal limits to either give a fine, give, like I said, and then the EFCC also, by virtue of Section 14, also has the power to compound offences. And today, under the current administration of criminal justice in Nigeria, you actually have, the novel idea of plea bargain. The prosecutors can have an arrangement with defendants now, have an agreement which will be entered as, which will be considered by the judge in sentencing. So all of these are all available legally. So these are legal, these are within legal parameters. So it now depends on the strategy that was adopted by a particular case. And don't forget that in sentencing and judgments, judges are judges are swayed by the case before them and legal arguments and the strategy that is adopted by the parties, provided they are within the limits of the law. So you cannot really fault the judiciary for giving imprisonment in one case and giving a fine in another case. That is something that the law allows.
Elvis, thank you so much for coming on. I appreciate you for doing this with us.
Thank you for having me.